Vice President.
Honourable Senators, before we continue debate, I crave your indulgence to revert to item 3 on the order paper, announcements by the President. Honourable Senators, the following is the correspondence from Her Excellency the President, Paula May Weeks, ORTT. Mr. Caesar. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Ms. Zola L. Phillips, whereas Senator David Small is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Zola L. Phillips, to be temporarily a member of the Senate with effect from the 18th of September 2018 and continuing during the absence from Trinidad and Tobago of the said Senator David Small, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 18th day of September 2018. Honourable Senators, a senator is required to take the oath.
I, Zola Phillips, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Senator Crease.
Thank you, Mr. Vice President.
coming late down in the batting order. Actually, really, there's three things I want to focus on. The first, of course, has to do with the question first initiated by Senator Prescott, responded to by Senator Simonet, and further elaborated on by Senator Choate. And it has to do, of course, with the provision which this bill makes for recruitment of judges outside of the jurisdiction. I think there's a tendency to overreact to this provision in the bill. I see it as a catch-all so that there's no need to return to this or the other house in case the occasion arises where there's problems with recruitment of judges. I take it that the AG would have had some level of consultation with the Commission or members thereof on the question of whether there are issues around the pool or the availability or the willingness to serve on the part of private practitioners in positions available under the jurisdiction of the Judicial and Legal Services Commission. So I don't have a problem with the provision. I take the point that Senator Choate is making. If we went to the trouble of establishing that Council of Education, focusing on the commonalities of Caribbean jurisprudence, that we shouldn't take action that would appear to close the door to Caribbean aspirants. So that perchance an amendment could be to have a pecking order so that the issue could be that in the first instance, we would survey, we would advertise the positions within the totally local jurisdiction of Trinidad and Tobago. And if that does not turn up, prospective candidates, then we go to the Commonwealth Caribbean, the Anglophone Caribbean. And then the third level could possibly be the Commonwealth. And then beyond that, the wider world. But there are some false assumptions, or there's a tendency to make some false assumptions. And those of us who are want to critique this provision, and it has to do with whether we think there may be a bias on the part of the Commission to automatically go international or automatically go to whatever level this provision in the bill allows them to go. And I think that's a false assumption for two reasons. One, in the past, we have not heard in their reporting any quest to go in that direction. But two, even if any commission, any employer for that matter, not just in the public sector, wants to go outside of the jurisdiction of Trinidad and Tobago, I'm sure the Minister of Responsibility for Labor would tell us that there are laws. And I'm sure, and this is the part that has puzzled me whole evening. All during this debate, I'm wondering, but aren't there laws, aren't there provisions regulating the recruitment of non-nationals? Isn't there a requirement for a work permit and so on? And wouldn't this automatically apply whatever the position you're applying for in Trinidad and Tobago? And if such a framework exists, then why are we acting as if this provision automatically means any lawyer anywhere or any lawyer in the Commonwealth could automatically turn up as a judge in Trinidad and Tobago. That is not an automatic process. So that's why I can't understand why there seems to be a tendency to push a panic button over this provision. I see it as a catch-all. Since we are here, let's provide for it and leave it to the competent authorities to perform independently. Because there's nothing that has been said thus far that has indicated to me that the Judicial and Legal Services Commission or any of the service commissions are functioning below par. That we have good cause to question whether their judgment, whether their processes, whether their methodologies, are wanting in some form or fashion. Nothing has been stated in the arguments 2 and 4 that in any way indicates that. And therefore, I'm at a loss to understand why there is this sense of panic, sense of fear that, we are about to recruit judges all over the place willy-nilly. Matter of fact, if I have a bias in this matter, it would be in respecting the commissions for over the past decade, upping their game in terms of the methods of recruitment and selection. And I'm referring to things like psychometric testing. That is par for the course now with our commissions. So the question raised by Senator Prescott, responded to by Senator Simonet, and added on by Senator Choate over the question of culture and assimilation and whether prospective candidates would have the kind of cultural fit, as it were, that would allow them to dispense justice to an even hand. I find this indicates the extent to which many of us do not have a sense of the level to which our IR and HR people, the people in the field of human resource management, the levels to which they have upped their game across this country. And I have been fortunate to represent the Commission as part of a recruiting mechanism. I myself have appeared before the Commission seeking elevation within the service at various points. And I remember at the point in which I sought to transit from the Office of the Ombudsman to the wider public service, particularly the local government area, and the vacancy for which I was being interviewed at the time was Deputy Town Clerk Point Fortin. And the question put to me by a member of the Statutory Authority Service Commission was, if you get this job as Deputy Town Clerk and somebody come and tell you, this is not the Congo, how would you interpret that? How would you understand that? This is not the Congo. That was a commission member saying that to me. This would have been somewhere between 1985 and 1987. This is not the Congo. And a reference to the Point Fortin borough. Between 1985 and 1987, that number of years ago, that was the kind of perspective members of the service commissions could bring to bear in an interview to see whether you are grounded, whether you understand where it is you want to go. And I understood back then what he was talking about because I understood the history of local government, even though I hadn't entered it at that stage. But I had studied public administration, and I understood what he was saying, is that there's a little racial brouhaha going on. Good? And that the compilation of the newly formed Point Fortin borough would have utilized workers from the old St. Patrick County Council, from that end of the region. And that they were, many of them were of a particular racial background, and that this newly formed borough had a particular ethnic composition. And the process of settling in and settling down in this new entity was still ongoing. And anyone functioning at an administrative level had to have a sense of that and how to balance those forces, how to satisfy the competing interests in that situation. And this was between 1985 and 1987. And this is how the commission put it to me back then. So I've had over the years a sense of that. I've had to function on behalf of the commission as part of the recruitment process as a deputy PS, deputizing for the commission and interviewing people to become CEOs in corporations, and faced allegations that, hey, given the particular party that was in power at the time that we were doing the bidding of the party, given the number of people we appointed where, without people having the information that given the number of people who applied, whatever we did, the shortlist would have had to be skewed a certain way because X didn't apply, but more of Y applied. So once you have that shortlist, and you have 9 people in interview, and you have 7 vacancies, and you have a majority for one ethnic group, have no way you could end up with more from the other if you do have them to interview. And that was the bottom line. So a lot of time, there's misinformation out there, right? That has to do with people not knowing and assuming. So I want to say that not knowing the processes that our service commissions employ, a lot of us are misguided. And therefore, we assume the wrong things. But also on this issue of culture and the role of culture in the whole management processes, including within the judicial and legal services. Sometimes we mistake elitism for a cultural factor. In other words, in a colonial era, the question as to judgment by your peers could be a function of the elites, especially if the elites would have originated from England or some, European, quote-unquote, mother country. And there's an extent to which a lot of us don't realize that in the post-colonial order, that elitism really could now be the question of what we like to call the 1%, the question of class divisions. Good? And whether class divisions are just as bad as ethnic or cultural divisions of the old post-colonial order. In other words, could I be from an ivory tower in this society and be appointed to become a judge with consequences, whether in the instance that Senator Choate gave us, whether all Afro-Trinidadians would have understood the cultural reference the attorney used, that it referred to as stool or a bench. Clearly, we know that the foreigner who was presiding in that particular matter didn't pick it up. Good? But that doesn't mean he alone would have been guilty of that, Good? I mean, I've been fortunate in that I was born in Faizabad, which is a corruption of the name of a state in India. And I know farmlands in Delhi Road, Faizabad, which properly pronounced should be Delhi Road, Faizabad. And the lands I own were Crown Grant lands originally given to East Indian indentured people, which I was able to buy over the years. So I've been fortunate. to be exposed to that, but that doesn't apply to every last Trinidadian of Afro-Trinidadian descent. So we need to understand that right here, inside this society, is the potential for not being fully assimilated and understanding all the nuances of the culture. So therefore, we have to understand at the end of the day, and this is as far I will take this discussion, that I think we can trust the commissions utilizing all the modern tools at their disposal to be able, if the need arises, and the provision is really, if the need arises, this doesn't mean the commission going off in the morning to only look for foreign judges. The Police Service Commission didn't do that with policemen. It is the political elites who set them down that track when they rejected the local offerings. Remember? So we need to be fair and not to assume the worst. I see this as a provision catering for a worst-case scenario, so we'll have to come back to the Parliament, and any good legislature would provide for all the possibilities in a given situation. So I see this as merely a provision for all the possibilities. And that our Service Commission will exercise its jurisdiction in a sensible manner, as it has in the past. But I want to assure people that there's a continuum, and we could always swing from the old elitism to the new. And the more pertinent question is whether there's any danger that we swung from the old colonial order, sitting on the benches and so on, to the new elites sitting on the benches. And there's possibly more danger there than the question of any foreigners coming to preside in our courts. The other issue that I feel called for some concern is that, again, and another aspect of this, we assume that all the other institutions are going to turn a blind eye, going to fall dead and stop functioning. So that's why I mentioned the role of the Ministry of Labor, the role of the Work Permits Committee, and so on. We assume just because there's a provision that you could recruit a board, instantly the Ministry of Labor, or whichever ministry has responsibility, good, for adjudicating over that, would instantly issue work permits. There's a process by which you have to go through to demonstrate that there is the need to go beyond the shores. Correct. So in that context, again, we keep taking the worst case perspective, and there's really no need for that. But it would help, of course, if a national policy with regard to recruitment would be elaborated so that people can be assured, fears could be allayed, that listen, nationals first, Commonwealth Caribbean second, wider Commonwealth third, some pecking order set up as a policy so that our commissions or any prospective employer, private or public sector, would be clear, this is the route to be followed, this is what you have to do. Good, if you are having a problem recruiting locally. And that recruitment policy should speak to all the professionals. Doctors, lawyers, police, teachers, whatever the nature of the profession. That policy should say how we would move through the system when we are doing recruitment. The thing about all of this, at the end of the day, there are two things which have emerged to me at a broader level. One is the the constant and overriding need for a clear consultation policy with respect to legislation. Because much of what the fears, the concerns that are being aired here could have taken place elsewhere. And I feel omnibus legislation, where you're going to touch 10 or 11 basic acts, requires that in the approach. Because you are going to be stepping on corns, you're going to be stepping across these various jurisdictions on key issues of philosophy. The concerns from Senator Paul Richards as an educationist, the concerns of Senator Choate, senior counsel. We need to understand that this requires of us at all times that there must be some amount of time for people to step back and take a second look. And there's need within our, in terms of the political parties, within their manifesto, to cater for these issues. This shouldn't come as a surprise. This should have been in the relevant parties' manifesto. This is what we stand for. This is what we had advocated for the country. This is what you could look forward to as part of government's policy. And in keeping with that, we are taking steps X and steps Y in the pursuit of that. And the wider discourse take place before we come to this place. Far too often, we have arrived here without that pre-discussion in the wider society, and then we try to substitute this for meaningful national consensus. This cannot be the place for that. This must come at the end of that. And finally, Mr. President, I think at the end of the day, the method informs the mechanism, informs the tendency for acceptance and goodwill. If these consultations were to be part of the normal course of things, and I don't mean my consultation writing a letter to the Law Association, because yes, they are relevant, interest body, but laws aren't passed for the Law Association, they're passed for the citizens of Trinidad and Tobago, and therefore they ought to have some fora in which they can participate. And I think it's in the act of participation, is in our commitment to that democratic process, that buy-in, even if people don't agree to all you do in the end, but that buy-in in the process, God, is meaningful. And that is where I find far too often these legislative attempts run into problems, because we could have covered this ground outside of this Parliament and come here just to do the fine-tuning. But I thank you, Mr. President.
Senator Mark.
Thank you very much, Mr. Vice President. Mr. Vice President, I rise to make my contribution on a bill which is designed to amend 13 pieces of legislation in order to allow, according to the explanatory note, for the streamlining of the processes as it relates to the treatment of children and children matters. Now, what we have before us very early is the injection of a provision in these 13 pieces of legislation aimed at amending, in the first instance, the Supreme Court of Judicature Act, and of course, several other pieces of legislation related to children and the treatment of children. Mr. Vice President, we on this side have concerns about several provisions or several sections, or clauses, I should say, in the legislation. I will seek to focus my contribution on a few of them, time permitting. One of those sections, or clauses I should say, is Clause 3. We have some concern with Clause 12. There is Clause 8 where we need some further clarification. And of course, Mr. Vice President, there's also Clause 14. So when we look at, Mr. Vice President, Clause 3 of the legislation, no one can argue, because it was done before, where in 2016, through a particular piece of legislation, this Senate increased the number of judges from 36, as you recall, Mr. Vice President, to 49. That was just roughly less than 2 years ago. There were other bills that were brought aimed at increasing family and criminal divisions, civil divisions. Several divisions were established. So we need to populate those divisions with more judges. So I don't think that one can argue against increasing the number of judges in our country. What I would like to posit is that when we are increasing the number of judges, we have to examine that in the context of the reality. And the reality is some of the key stakeholders, one of them wrote to the Attorney General, that is the Law Association, outlining some of the association's concerns as it relates to the implications of this provision, along with others, for the legal profession, as well as for the administration of justice. And they advance the need for us and the need for the government to pay attention to the method of appointment of judges in this country. Because as you know, Mr. Vice President, we have had some challenges in our society over the whole process involving the appointment of judges. And in this regard, I want to ask the Attorney General, I want to allay his fears. Because when he spoke to this Parliament on the 2nd of July, 2018, on this very bill, he stated, and I quote, "Then I prefer most respectfully to err on the side of the provision of a greater judicial complement, because Trinidad and Tobago must be aware that improving by way of legislation or reform the judicial and legal service method of appointing judges will require us to amend the Constitution. Dare I say, I am not confident that the UNC in its current inclination, well, it's an inclination, you said here, not incarnation. In its current inclination that he said, maybe he has to correct that to say incarnation, is prepared to accept anything that requires a 3/5 majority. That is what my honorable colleague had said. So I wanted, in my contribution, Mr. Vice President, to allay his fear. If it is that you are using the fear of the UNC in order not to proceed with amendments to the Constitution as it relates to a new method of appointment of judges to the Supreme Court of our country, I would like to advise my honorable colleague that that is a matter that he can discuss with us. Because we too, in the United National Congress, like the Law Association, we have an interest in promoting democracy, transparency, accountability, and more openness. And we believe that the method of appointment of judges is very critical in this particular regard. And I would say, Mr. Vice President, that if it is that the Attorney General was a bit concerned about getting our support for an amendment to the Constitution as it relates to this question of looking at a new method of appointing judges, I would ask him to withdraw this provision and hold consultation with the opposition with a view to dealing with the same question of having a new method of appointing judges to our courts. Because, Mr. Vice President, there are concerns not only by myself, but, you know, I listen very attentively, not fully, I must say, but I listen somewhat attentively to many commentators when this matter of the law term opened. And I must share with you, I want to tell you, first of all, we identify with the Law Association in its call for a new method of appointment of judges in our country. And I want to quote from the Guardian of Monday, September the 17th, 2018. And it's on page 3. And it's a quotation from one judge, Frank C. Prasad, and in which, as a sitting judge, which is a bit unusual, as you would imagine, but you know we live in unusual times because the PNM is in power. So you have extraordinary decisions and actions taking place. So Mr. Vice President, hear what the judge is saying, and which, if you listen carefully, he's reflecting the thinking in terms of a modern judiciary. He said, and I quote Mr. Vice President, conversations are taking place about the need for more judges, but no focus is placed on the method of appointments. If one truly understands the importance and critical role that a judge plays in a democratic society, the need for increased numbers must be reviewed against considerations of competency, credibility, cultural, and socio-economic concerns. And within this context, he mentioned the need for us to look at reforms of the Judicial and Legal Service Commission. Mr. Vice President, there's a report that was mentioned earlier in this debate. It is a report by the Right Honorable Mr. Justice P.T. Georges. It is entitled Independence of the Judiciary. It is dated February 16, 2000. And I go to page 4 of this report. And what is being said here is very, very important. He's talking about the independence, and he's defining the independence of the judiciary. And he was saying that to ensure that the Supreme Court, which is the institution ultimately charged with the protection of the fundamental human rights and freedoms of all persons in Trinidad and Tobago, can fearlessly enforce those rights when called upon to do so. So he's talking about the independence of the judiciary and the importance of the Supreme Court. Now, Mr. Vice President, you're a young man, and you have a long way to go. I want to tell you, Mr. Vice President, that if you are not aware, let me inform you. When you appoint a judge to the bench, it is like you're appointing somebody for life. It is not for life. I'm saying it is like you're appointing the person for life. That person, whether he's a puisne judge or a member of the Court of Appeal, he has until 65 years to sit as a judge, or even longer, as my good friend is saying. So what we are saying, Mr. Vice President, is that my colleague, Senator Saddam Hussein, was indicating earlier in his contribution how we have gone from one level or one phase to another phase. It was a tap on the shoulder when you met in secret circles. You want to be a judge? Okay, you'll be a judge. And you are a judge after that. And then it went up to another level. And we have a level now where we are told by the Honorable Chief Justice there's a rigorous process that is involved in this whole exercise today. Very, very rigorous, and that could be compared to anyone, any similar process, or even superior to many in the Commonwealth. But you know what, Mr. Vice President? We are saying that in a modern democracy, in an era of accountability, openness, and transparency, we need to have a more open approach to the appointment of judges. Mr. Vice President, we are going from what? 49, you know. Mr. Vice President, in 2016, we are 36. We went from 36, Mr. Vice President, to 49. So we went from, we increased judges, the number of judges, by 13. And that is less than 2 years. It came here in 2016. In 2 years, we increased the number of judges by close to 16, almost. 36, 40, 49, 13 judges. And Mr. Vice President, here we are today with another major leap into the future. And we are appointing how many? We are asking to approve how many, Mr. Vice President? We want to go from 49 to 64. 15 more judges. Which would mean that in less than 2 years, this Parliament would have approved 28 new appointments in the area of puisne judges of the Supreme Court. Now, that might be a good thing to clap for, because I think that is a good thing to have plenty judges. But what we are asking here, Mr. Vice President, is the appointment process. How are you going to appoint these judges? Who is going to appoint these judges? Mr. Vice President, is it the same process we are going to use that threw up a judge today who is before the courts? Is it the same process we are going to throw up today, Mr. Vice President? Where, for instance, when you appoint a judge, as I said earlier, he is there or she's there until the age of 65. So, Mr. Vice President, what the government is doing, and if they don't know it, let me tell them what they are doing. They are saddling the next generation or two with judges who will be appointed to the bench by a current administration where the whole process has been brought into question. And we are asking and advancing that there is need for a rethink on this matter. We need, Mr. Vice President, a new appointments process where we will feel confident as a population that when you appoint a judge to sit, Mr. Vice President, may I remind you, Justice Telford Georges indicated that when you put a person to sit on the bench in the Supreme Court, that person is the guardian and the protector of our fundamental human rights and freedoms. So a judge, Mr. Vice President, is a serious position. It's a very, very serious position. So this is why, Mr. Vice President, we are suggesting that the government must mash brakes. Here. Mash brakes. Mr. Vice President, if the government is interested in increasing the number of judges, you don't have to come and amend the law now. Because there can be many assumptions that I can put on the table for your, I'm saying assumptions, for your consumption. that will deal with some of the dangers that we can face as a nation and the dangers that our democracy can face as a nation in the future. I have been in Parliament for several years, and I've never seen a government in 3 years about to admit office next year. Moving so rapidly to a point, listen, you're talking about 16 plus 13, almost 30. Mr. Vice President, what is the objective behind that? What is the thinking behind that? Why is the government moving in that direction? Who called for all those judges? Was it the Chief Justice who called for more judges? Was it the Law Association who called for more judges? Was it, for instance, the Southern Lawyers Association? Who called for these judges? We didn't call for it. I don't know the ordinary people have said they need more judges in this country. But all of a sudden we have more judges. And then we have this talk about Ghana and we have Nigeria. That they already line up judges. I'm telling you what I'm hearing. That they have already lined up judges to come here when this bill becomes law to become judges. Let the Attorney General deny that. Are there judges lined up from Ghana and Nigeria to come to the bar when this bill becomes law? And why are you bringing judges from Ghana and from Nigeria? I'm an African, so you don't come and tell me about no race. Don't come and tell me about as somebody was saying in a speech yesterday about ethnicity and all kind of nonsense. I am saying, Mr. Vice President, when you're talking about justice, no race, no class, no color. You want to make sure, Mr. Vice President, that we as parliamentarians uphold our Constitution. That is what we want to ensure. So I would like to advise the government, if they are interested, Mr. Vice President, in extending and expanding the pool of judges, they don't have to go the route of amending the law for the first time since our independence to bring, Mr. Vice President, any member of the bar from the Commonwealth who has practiced for whatever period of time to apply here in Trinidad and Tobago to become a judge. Look now, man, if you're in France, you have to be a citizen of France to be a judge. In America, you think any stranger could go in America and become a judge? You have to be an American citizen to become a judge. So why are we watering down the brandy here? What is the objective, Mr. Vice President? Is there an ulterior motive behind this move to increase the number of judges from, Mr. Vice President, 49 to 64? Is there an ulterior motive? I don't know. I'm just putting that out. I'm asking questions. Mr. Vice President, backlog? You don't have no courthouse, boy. We're going to do backlog. And you say, I know you're becoming the new General Secretary and you're very anxious to take that post and occupy that office. But, Mr. Vice President, we have no courts. You know, Mr. Vice President, what is interesting? There we have no courts. You know it will take almost about 5 years to complete a proper judicial complex in this country, given how we operate in this country, the bureaucracy. Yet still, Mr. Vice President, the government in 2 years, Mr. Vice President, is moving towards engaging over 20-something judges. What is the purpose? And then, as I told you, you're hearing all kind of talk, Mr. Vice President, that they have people line up from Nigeria, from Ghana, and so on. Let us know if that's not true. We'd like to know that, Mr. Vice President. Mr. Vice President, I would like to tell you, if you don't know, there's a book I would like to recommend for reading. It is entitled How Democracies die. I think that is a seminal piece of work. No, it's written by a fellow called Stephen Levinsky and Daniel Ziblatt. Mr. Vice President, and you know the essence of that book? They're talking about Trump in the United States. How he's undermining the American democracy. And Mr. Vice President, you know what is their thesis and their theme and the most important part of the essence of that piece of work? Mr. Vice President, hear what these writers are saying, Mr. Vice President. They say no longer are democracies overthrown by generals and guns. Democracies are no longer overthrown by generals. They are overthrown and subverted by the very people who were elected democratically by the citizens. That is what this book is saying, Mr. Vice President. So what we are advancing to the Honorable Attorney General for his consideration is the following. Mr. Vice President, we want him to delete Section 3. Clause 3, we want it to be removed completely from the legislation. We are proposing to the government, Mr. Vice President, engage us, the opposition, in serious discussions on a new method of appointment of judges before you appoint any new judge or judge in this country. And because of the very controversies that surround the current holder in that office, Mr. Vice President, I'm not casting any aspersions. I'm simply saying because of current controversies in broiling that judiciary, it is not appropriate to allow that Judicial and Legal Service Commission to be given the power to appoint these 16 new judges. That is what we are advancing here. So we are saying delete, remove completely that provision, and we say match breaks. Match breaks there. Mr. Vice President, I have alternatives for the government's consideration. Whilst we hold up on these appointments, we are asking the government to consider the following. Mr. Vice President, retired judges who leave the bench at 65, you can bring them back on contract for 5 years, as they did with Dial Singh and Ibrahim, who has now passed on. There are many judges, brilliant judges, who can be brought back onto the benches of this the Supreme Court and Court of Appeal, and you bring them on a 5-year contract, Mr. Vice President. Mr. Vice President, we don't need foreigners in our country to tell us how to make decisions as it relates to people's guilt or innocence. We don't need that. That is neo-colonialism. We don't want to be part of that any longer. We are a sovereign, independent state. We have 1.5 million people in this country. We have outstanding citizens in this land, Mr. Vice President. We have brilliant sons and daughters of this. And you want to bring people from where? Turks and Caicos? No, Mr. Vice President. The government can't be serious. The government has an ulterior motive for wanting to do that, Mr. Vice President.
No, the suggestion...
All right, I withdraw it. Mr. Vice President, may I go on? Because I don't want you to get up again. All I know is good for your legs, because you need that exercise. Mr. Vice President, let me indicate as well to you, there is need, Mr. Vice President, for us to consider raising the retirement age for judges in this country. Mr. Vice President, you don't have to go at the age of 65. Senator Mahabir made the point that when you leave at the age of 65, Mr. Vice President, you cannot practice law as a lawyer for 10 years. By that time, Mr. Vice President, you pass your 3 scores and 10, and Almighty call you home. So, Mr. Vice President, what I'm suggesting to the government is that you could increase the retirement age to 75 years or 70 years. No, I'm saying, Mr. Vice President, whilst we are seeking, Mr. Vice President, like my colleague who likes to interrupt, that is Senator Paula Gopi School I'm talking to, through you, Mr. Vice President. I'm not saying this is a permanent solution, Mr. Vice President. I'm saying it's an interim measure as we seek to put in place a permanent system by amending the Constitution as it relates to the appointment of judges in the country. That is the point I'm making. So, Mr. Vice President, I'm saying in the meantime, what we do, we hire retirees, give them a 5-year contract. And secondly, we extend the age temporarily to retire from the bench from 65 to 70. We believe that you'll be able to attract quality people to the bench, Mr. Vice President. So that is a proposal that we would like the government to consider, Mr. Vice President. Mr. Vice President, I was doing a piece of research as well on what happens in France. And Mr. Vice President, they have a different culture, a different system, but I'm doing the principles. They have what is called the National School for the Judiciary. A national school for the judiciary. You cannot become a judge or a prosecutor in that place called France unless you go through that school that is established for you. And you have 3 levels, 3 entry levels in terms of examination that you have to take and you must pass, Mr. Vice President, in order to practice as a judge in France and in order to become a prosecutor in France. And not only that, Mr. Vice President, there is a continuous program of training for the French judges and prosecutors. So that is something that if the government is serious about improving the quality of judges in our country, the government should give to the judiciary the kind of resources, or the government can, in fact, provide them with the resources in order to do what? Establish a school, a national school. Madam President, I'm so happy that you're back. that doesn't mean that my friend gave me trouble, eh? Yeah, so, Madam President, I was saying that I was reading, in doing my research here, I was reading about this very important school in France, and it's called the French School for the Judiciary. And I would recommend that the government invest resources in such a school. Attorney General, I'm sure that you're familiar because you're a widely read individual, and you must be aware. I'm not dealing with the cultural context. I'm just dealing with the principle of having a school established for judicial officers in our country. And this is a very good suggestion, or a very good thing that they have in France. And I would like to suggest that it be considered by the government, Madam President. So, Madam President, this is one of the areas that, as I said, we have some concern with. And I want to serve notice on the government that we are going to be proposing several amendments to the legislation because there are several areas that we have discerned as weakness, as very, very weak. And we intend to strengthen those areas. And we intend to serve notice on the government of those amendments that we would like to advance. Madam President, I would like you to also look briefly at clause, I think it's clause 7, if I'm not mistaken, clause 12, Madam President. And that clause 12...
Mark, you have 5 more minutes.
Yes, thank you, Madam President. Clause 12, Madam President, deals with the family law guardianship of minors and maintenance. We have an amendment here, Madam President, where, for instance, this body, under the auspices of the judiciary, and in the name, this bank account, I should say, is going to be the name of the Registrar General, but under the broad rubric of the judiciary, and they will have the power to impose fees. We would like to insert a clause here indicating that the Rules Committee, which is going to impose those fees, that the Rules Committee, all rules made under this section shall be subject to an affirmative resolution of Parliament. So we want to ask the government that before you impose fees, you get the permission of the Parliament to do so, or the approval of the Parliament to do so. Madam President, there is a provision in section 14 which deals with family and children's division. And Madam President, I want to tell you that there is a lot of disquiet. Attorney General, through you, Madam President, there's a lot of disquiet at the Children's Authority. There appears to be a loose cannon at work. His name is Hanif. Hanif Benjamin. He said he's from the United States. Hanif? Well, wherever he is, that's not my interest. My interest right now is that we have done some research on this gentleman, and as far as we are concerned, Madam President, we need the Attorney General to conduct an inquiry into the operations of that Children's Authority. We understand we have a dictator in the making there.
Please take your seat. I have repeatedly cautioned members of this chamber. You have freedom of speech, but I ask you, please, when you're speaking about persons who are not members of this chamber, to really, show some restraint. You can make your points, but you don't need to make it in the way that you're doing it. Okay, Senator Mark?
Well, you know me. No. But I understand your point, Madam. Listen. I'm speaking today. You're thieving my time. Madam Chair, can I address you and protect me from this? I am guided by the President, not by you. The President has ruled. I am following the orders of the President, not those orders there. This is not PNM, Madam President, Madam President, I also want to bring to your attention a matter. Madam President, may I?
Please, members, I don't know. You all greeted me so happily, but now I'm getting a little concerned. I just want to say, please, let us remain on the straight and narrow. I would ask members to listen to Senator Mark in silence. Please.
Thank you.
Senator Mark, continue.
Madam President, thank you very much. Madam President, I wish to bring to your attention another matter that was drawn to my attention. It deals with a form that was issued by the Ministry of Education to all maxi-taxi drivers who pick up children under the age of 18 to take them from one point to another. That is from the point where they pick them up, drop them to school, pick them from school, drop them back to... And Madam President, this form is asking the drivers to get the names of the children. No, I'm talking about Madam President. Madam President, may I seek your protection?
If any senator wishes to rise on a standing order on the point of relevance, do it in the proper manner, please. Continue, Senator Mark.
Thank you for your protection. Yeah, Madam President, we are dealing with information, confidential information, on children who are being collected and transported by maxi-taxi drivers. And the Ministry of Education, in a form I can pass on to you, Madam President, is asking...
Point of order 46-1.
Well, Senator Mark, I did give you the 5-minute warning, and your time is up.
Okay, thank you very much.
Okay? Senator Ramkisoon.
Thank you, Madam President. Thank you for the opportunity for acknowledging or giving me the opportunity to speak on this Omnibus Bill 2018 and also referred to as the Miscellaneous Provisions Bill 2018. This debate has been going on for almost 3 days, which is a good opportunity because I've been given the opportunity to hear from multiple senators and their different views from all sides. And it really was an informative debate on the different pieces because there's 13 pieces, well, I've counted 12 pieces of legislation that we are looking to amend through this omnibus bill. And it is something that I can agree with the Attorney General that it is an important bill because it deals with family and children matters and actually having that uniform across the board approach to aligning what we have passed in this 11th sitting of the Parliament in relation to the Family and Children's Bill. So we did lump a lot of pieces of legislation in one. I am always not in favor of that because I always believe you can easily miss something. But in this lump sum, we also have the DNA legislation and the Supreme Court's of Judicature Act. And I'm not certain why we did that approach to lump everything in, but I am happy to join in this debate. And at the last sitting, Senator Haynes ended, and she did raise a very intriguing point. Why is it that after having all of these legislations debated in the 11th Parliament, that now we are bringing this approach or these pieces of legislation back before us, but not taking up the recommendations that we as senators would have laid before the Senate? And a simple example is the DNA legislation. When we looked at it, it's Clause 6 for Bill 5.34 DNA. The only amendment I saw here that we are changing is the change from the juvenile residential facility to the rehabilitation center. And I was a bit taken aback because I was thinking this was a perfect opportunity to raise other points of the bill that we would have raised when we debated it on the 29th of May, 2018. So I do agree with Senator Haynes' point that this was an opportune time that we could have taken here. We are all sitting here. We have used 3 days of debating time that we could have dealt with many important things that dealt with in the Parent Act that we didn't have the opportunity to amend for time constraints, and this was the opportunity we have, and now we are missing it. So I'm very displeased with that approach to how we have laid this piece of legislation. But nevertheless, we are here to debate and to amend issues or matters with the courts and as well as the Family and Children's Bill. And Madam President, there was a lot that was said by different senators, and I do not want to repeat any of it. I just want to build on the points that I thought was very important and we need to pay particular attention to and not let it pass by. We are always reminded that we are legislators, senators without the portfolio of ministers. So we always pray and we plead and we speak through our words, hoping that the policy makers and the ministers before us would hear and take heed to what we say. Because we do not have the authority to protect and serve. There are different agencies to do such. We are here to legislate and only influence those who present bills before us to make amendments or changes or to take heed of what we are saying. That's the only opportunity we have here in the Senate. And I take that position very seriously, and I do plea, and the point that I raise is just to ensure when we have laws that we take heed of what exists in our country and how it will affect those when it is operationalized. So, Madam President, I want to just touch on a point that Senator Ramdeen had raised in his debate, and he was addressing, and I hope I do not misquote him in any way, that the point on the limited resources in the courts and the number of unsolved cases. And he was speaking about all the victims in our country, of kidnapped victims who are still outstanding, unsolved cases. And he did highlight the successful case or the successful extraction of Mrs. Pollinier. And I thank God for that success, or the TTPS, to return Mrs. Pollinier to her family. And I want to raise or reiterate a point that I have raised in this Parliament before, and it's in relation to the TTPS. There is a system that they are involved in, and I have not read about it in any of the laws before us. And I'm not sure if this is a legal process. It's called the traffic stop, and it's called a database. I asked them to look at the form because I've been stopped 3 times. I'm not sure if as a female driver driving alone that I pose a threat, that I've been stopped 3 times for the same reason. It's a handwritten form that they ask me my name, my address, where I work, my eye color, my hair color, my thing, by 3 different officers. This last time I asked for the officer's name because I was a little bit concerned, and at 3 different points too. One at Urupu Junction, Rosilac, and in Guapo. And I'm not sure what is being done with the information, because immediately, Madam President, if on the 3rd attempt, you should know that you stopped me twice before. So after learning of the recent developments in our country with Mrs. Pollinier case, I would like to plead to the Attorney General and to his cabinet to really look at this TTPS traffic stop and what is the purpose of stopping people at different times of the day to ask them questions, which I don't know if they know I'm telling the truth, but they're asking me to answer questions. And it's very personal questions too, like where I live. If I... Oh gosh, well, this is my way of raising it because, Madam President, after learning this, if I'm stopped for the 4th time, what do I do? Do I drive? Do I continue? So this is all I want to raise with that.
Senator Ramkisoon, members, Senator Ramkisoon, I need to just caution you. I know it's early on in your presentation, but all that you just said, I'm not too sure how it ties in to what we are dealing with right now, okay? So.
Thank you, Madam President. Well, that was just the end of that, actually. I was moving on to my other point. I just wanted to raise it at this time since it was raised earlier in the debate on the first day of the debate. I want to also raise or actually support the comments that was raised on the rehabilitation centers by Senator Jennifer Batiste Primus. And I do support the government's initiatives to focus on the rehabilitation of children and to reduce children crimes through focusing on programs for them. My only concern or question is how are they aware of the programs that are available to them? Because these children are placed in areas or in homes that they are not aware of anything other than a life of crime or a life of darkness. And we have to be mindful of that because these children, the only fear they know are returning from school to go to home. They know the fear of seeing gang members at blocks. And that is the fear. And I've heard many of it from the Ministry of Education, principals, and there is a clause that deals with that, where the minister with the responsibility for education shall, after consultation with the Commissioner of Prisons, appoint educational instructors. And I don't know if these educational instructors can now empower these children by sharing the initiatives that the governments have in place to keep them out of a life of crime and out of having to rely on rehabilitation centers because you're trying to get them before they reach there. So I have not heard about the educational instructors before. I'm not sure if this is a new creation or new job portfolio that has been created for the Ministry of Education, but it really does need to support the present-day principals and teachers that struggle with these things, especially with schools in rural areas. And Madam President, I actually had a principal that told me that a young child brought weed to plant in the school and they didn't know it was a crime. So you see these things, they do not know they are doing criminal offenses or activities, and we have to be mindful of those things because we need to protect the innocence of our children. And Madam President, we're seeing that social issues continue to plague our country. And as legislators, we must be mindful of such, because we just can't speak here and not understand that the country needs to trust that we have the best interests at heart, and trust that when we sit here and agree on pieces of legislation, that it will help them and serve them and have a better tomorrow, a better future. And I was listening to Diana Mahabir-Wyatt's speech at the law term opening, and she was sharing her experience dealing with children and children court and children family matters, where it was from when she started to where we are now. And definitely we have grown, and we have successful pieces of legislation which we are trying to amend to give more empowerment. But she also raised a case where an 11-year-old girl was sentenced to prison. And when they checked, they had more than one young adolescent in our prison, which is deemed unlawful. And how is this happening? And she shared that how magistrates will be seeing a child maybe more than once, and this makes a child's voice not be heard. And we tend to ignore sometimes that a child will not listen to an adult if they do not feel that they can trust or hear or take heed. And that's something that I want us to just be mindful of. Another point that was raised, or another point that I've seen here in this bill, and that is with 1305, the Child Rehabilitation Center Act. When I did look up the act, though, it had stated Young Offenders Detention Act. So is it that we are changing the long text title of the bill from Young Offenders Detention Act to Child Rehabilitation Center Act? And that, okay, sure.
In 2016 by Act number 6 of 2016, but I appreciate because Senator Ramlin raised the same question of access to the updated version of the laws, which I know the Law Revision Committee is working on as we speak.
Thank you, Attorney General, through Madam President. And I did go on the website from the Attorney General, the Legal Affairs website, and that was the latest one I saw. So if the revised edition will be further amended or sent through the, circulated through the online versions, we would like that information to please be circulated when it will be updated on the online system. So when we do pull it up, because that's what we always compare our legislation or the bills before, we always compare to the online version or the Legal Affairs website. So that's why I raised it, because I did compare it to that. Another issue or concern that was raised during this debate that had very strong merits to me is the issue of, how do you put this? The psychological trauma that is faced. And a Guardian article by Camille Clark on March 25th, 2015, Single Parent Linked to Poverty. And it gave some statistics that children of single parents are 6 times more likely to be poor. And Edward Clark did a research, and he said that it was noted that the absence of fathers in families lead to tremendous consequences. It even went on to say that the findings that 60% of the women that were incarcerated at the Golden Grove prison and 60% of the boys at the Youth Training Center were single mothers and had absent fathers. And that, for me, stood out. And Senator Dottin, Pastor Dottin, when he was here as a temporary senator, he raised the point of the link of single parents and how it impacted on the growth of the children homes and the institutions. And I would like for the administration to look at this seriously, because it now dampens or put a damp on our public sector and our budget, because now we have to look at social services and money for such. So I want us to be mindful, because if you look at clause 1305 for 2AD, it has an application for children to get permission to who have reached the age of 16 to enter on-the-job training. And this is in the rehabilitation or children who have offenses against them. And all of this would play a key role in how we will be addressing issues facing our youths or our youth offenders in our country. And this is one of the clauses that I would like to commend, which is the 13052A-D, which gives these children an opportunity, because they may not have that opportunity before, but after being treated differently, because if you can see the home is damaged, they are looking for it on the outside, and this is an opportunity that we could really embrace and really have, because you have to do it through a court order to allow the child to get a job outside for training. And this is something that I would not want to see falling short, but actually have the provisions enforced in the different homes and centers. Madam President, while I was reading the different pieces of bill, I did see a concern to me, and that's 420 Summary Courts Act, Section 2, in the definition of the guardian. We are asking here to delete and substitute the word child with younger child, which we are defined as someone who is 7 years to 14 years. And my question to the Attorney General, through you, Madam President, what about children who are 14 to 17? So we don't need a guardian for those children. They can represent themselves. Okay, well, no problem. That was my only concern in that. For younger children, we're only catering for them in the guardian definition. The Senator Church is now telling me that they may not need it. Yeah, this. Okay, let me see if I could clear it up better. So, all right, so in the 420 Summary Courts, we have we are being asked to alter the definition for guardian. For child to be, for the younger child, only take in consideration ages 7 to 14. And my concern was, what about children who are 14 to 17? Because I was looking at other pieces of legislation that we're amending, and when you need legal aid and legal advice, you would need a guardian. So that's why I wanted to know why we did not just leave it as a child and have all persons 7 to 18 included. That was my question in relation to that. Madam President, throughout this omnibus bill, we have seen the reference to children probation officer. And this is truly something that we want functioning. My question, which I hope can be answered, is how many children probation officers do we have in Trinidad and Tobago? And have we related it to a ratio? 1 probation officer to 2 children homes, or 10 recreationals, and how do we have it now? And really, because Madam President, when you visit children homes and you hear their stories, it seems like this position does not exist. So that's why I'm asking, if then the Attorney General is giving his wrap-up, that he can share with us the numbers of how many and how many do they intend to employ if there are vacancies within the system. Because this role is something quite critical for the survival of these children in these systems or these institutions. Madam President, another point that I wanted to just raise, and that is in relation to the Commission of Prisons. And many senators have raised it and made their pleas to different lengths to the Attorney General to reconsider the additional portfolio. And my concern was based on the response given by the AG during the debate, which was related to that the Children's Authority will have the authority to enter centers and homes and assist with the commissions or the commissions of prisons authority or their powers. And when I read the pieces of legislation before us, this is not what I interpreted to be. So the Commissioner of Prisons has the sole authority. We have heard many senators ask that it doesn't be under the remit of the Commissioners of Prisons, but it be under a different division. And when the response was given is that they would also have Children's Authority would have a greater involvement. But this is not what I've seen. Because if we look at in Section 3.1 of the Rehabilitation Center Act, we see that we are asking that the control and management of the Rehabilitation Center be given to the Commissioner of Prisons, and it is subject to the Children's Authority Act and the Children's Community Residence Foster Care and Nurse. And Madam President, when we even look at the Children's Authority Act, Section 5 and 5A, it doesn't show any additional powers that these Children's Authority Act, other than to provide care and protection, investigate and make recommendations, investigate complaints, investigate. But if you look at another option here, it says that in the authority will have the opportunity to consult with the Commissioner of Prisons. Now, we have learned that consultation does not mean accept. It just means advice given. It doesn't have to be taken at any point of time. So we are thinking that the Children's Authority has a lot of power given to them. But really and truly, that's not the case. We are just asking them for advice or consultation. And this, I think, is a step that we should really reconsider. If you want to give them more authority, then give them it. Don't put in the words consult or subject to, because then you're taking away their powers that you really would like to secure. If that is the powers that you would like to give them, because that's what I had interpreted from the AG's response, that is where we would like to head. But I could have been misunderstanding what the good AG had said. Madam President, another point that I wanted to raise is something that I did not see. And if it is in the Parent Act, that is great, but I was unable to find it. And that is in relation to, if I could find it, 12D, Section 2. And this deals with fines or liable to summary conviction to a fine of $5,000 imprisonment for 3 years if a host or a parent or person is unable to present a child to the rehabilitation center at the said time. And my question here is, why did we want to go that way? Which is great. We want to give the opportunity to a child to have the opportunity to visit their parents or their a responsible host after submitting information. But what if the child runs away from this host environment or this address? What happens? And I did not see that for the Rehabilitation Act, but I did see it for the Act. Let me see if I could. Honorable AG, I was hoping you would have the consolidated form here. It's very difficult to thumb through the different bills, but in relation to the Children's Home, which act is this? Children's Community Residences Foster Care Act, there is a provision for children if their child runs away from the home or from the person to whom he has been temporarily placed, the authority shall apply to the court for a recovery order, and the child shall be sought to the authority and shall investigate. So that's my question. We have put in provisions in the Children's Foster Care Act to allow if a child has run away from the temporary host, but what about for the temporary host for the child who has an offense against them? What will happen? Because the only thing I'm seeing here is that the parent or the host provider would be charged, fined, or imprisoned. And I think that is a loophole that we need to address because we don't want that to be a case. Madam President, another case that I wanted to raise is 4601 Child Act, and the child is in need of a supervision 50A. And I really like this clause, actually, and the wording, if I could ever find it. But it gives the powers to children who who need supervision in our country, and the parent is unable to control their children. And this is why I want to highlight this at this point, is that many times in Trinidad and Tobago, we have this saying that we make the child, but we don't make the mind. We always hear that, and they put their hands up, and they allow the child to do as they please. But here we are putting in a provision in the bill or the law that says if you cannot perform your duties as a child, and this child is a parent, sorry, you cannot perform your duties as a parent or a guardian, and now you can ask the court to provide legal aid, to provide counseling, and they have given 3 options that can be given to you to allow you to assist you in your guardian or parental duties. And I thought this was great. That is 50A of the Children Act, that we would give that power or empowerment to parents. Madam President, there is another section that came up, which is 24E, order that the parent, guardian, or person with the responsibility of the child be referred for counseling. And I wanted to know if this counseling would be offered by the state, would it be paid for by the state, who would be allowed this cost, so who would hold this cost, the parent or a guardian who has a child who has an offense, who would offer this counseling? We have it in our bill that we will be giving them counseling, but who would be doing this? Is it at the children's home, at the recreational center, the rehabilitation center? What is this? And Madam President, if you visit any of the children's home, they will say one of their shortcomings is that the counselor doesn't come every week. And that's something that is concerning and alarming. And when we want to put provisions to protect children and we don't have the systems working, then we are also making it a failed attempt at what we are doing here today. Another point, or maybe my last point, that I want to raise is Section 75 and Section 83 2E. And this deals with placement for a child convicted of murder. And we are asking that where a child has been convicted of murder and the court is of the opinion that no punishment, which under the provisions of this act, is authorized to impose is appropriate, the court may sentence the defendant to be placed at a community residence for such period. And if you read on, Madam President, you will see that there's also the option to transfer a child from a community residence to a children's home. I have a big option that I would like that not to be there, because I would not like, because of space, that these children just not be put into the rehabilitation center, but placed into the children's home. And that's why when we were listening to Senator Pastor Dotton, he said that the homes are asking for psychometric testing of these children. And that's because all types of children enter into these children's home and they're unable to address their needs because they don't know their wants. And it's very sad because the counselors or the persons from the state takes really long to come to the homes. Well, I can speak for the ones in South. I don't know about the ones in North Trinidad, Tobago, or Central. But that is the feedback we get. And that's why I would not like that provision to be placed into law where the transferring or movement is so easy, especially for children who have committed murder or have serious offenses against them. And we don't want it to be the case where you're just waiting for them to age out to 18 and over so you can actually make a conviction, which is what has happened most of the cases because it takes so long to be heard, these cases to be heard. So, Madam President, that is not a good way to deal with it, or even to put the priorities or the concerns of children into our law books. We are not going to say, okay, we're just going to leave you there. It's somebody else's problem until you reach 18, and then we will do a judgment call against you. No, because it's somebody else's problem, is unable to handle it, and one child teaches the tricks of the trade to the others. And the smaller children always loves the bigger children. And you don't want these influences to be happening into our children's homes, even our rehabilitation centers, because they cannot be looked at 24 hours a day. They will have playtime, they will have areas where they will be talking. Children have their own language of communication, and we do not want to fail them continuously by leaving out these gaps or these areas that really impact them in a big way. And Madam President, I have read this bill. It's a little bit tedious to go through all the clauses because there's so many things that impact another point. But I just want to close on an example that is very real in our country. We all celebrated with our cricketers at the CPL final on 2018 on Sunday. After the game finished at 10 p.m., at 11:30 p.m., I'm driving to Marabella to escape the traffic to go home. And while I'm passing through Marabella at 11:30 in the night on a Sunday, I'm seeing children, male and female, playing football on the street. It's a Sunday. Are they going to school? Well, they're not working. It's a weekday, something like that. And I can't understand why. And this is what we have been, well, we would say, why is the police allowing this? Why not doing patrols? But again, Madam President, if we are not letting the administration initiatives be known to all of these areas, then the system will continue to repeat. The growth of this wastage of our nation's youth will continue. And the fight, they say, oh, in every dunghill there's a rose. But I wouldn't want just one rose. I would like a field of roses. And I would not, it would be unfortunate for me not to raise these things as a young person in our country. Yes, the fight is real, but we have to remember them and not only think about the law books and how we are continuously trying to amend the laws to fix it, but implementing systems to make sure the social issues don't continue to grow in our country. And I thank you.
Senator Phillips.
Good evening, all. Thank you, Madam President, for recognizing me and affording me the opportunity to join this debate. Also, it would be remiss of me not to thank Her Excellency the President for reposing her confidence in me to represent the people of Trinidad and Tobago. It is indeed an honor to be here in this august House. The bill before us is an act to amend the Interpretation Act, Chapter 301, thank you, the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Bail DNA Act, Chapter 534, the Legal Aid and Advice Act, Chapter 707, the Child Rehabilitation Center Act, Chapter 1305, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Children Act, Chapter 4601, the Children's Community Residences, Foster Care and Nurseries Act, Chapter 4604, the Children's Authority Act, Chapter 4610, and the Family and Children Division Act, 2016. I would like to begin by firstly congratulating the Honorable Attorney General and the government on their effort to move legislation forward, especially as it relates to the judiciary and our children. I took this opportunity to make my maiden contribution because the topic is near and dear to me, as my background is in psychology, forensic psychology, criminology, and criminal justice. In fact, I'm a lecturer with the University of the Southern Caribbean, and this semester, thank you, and this semester I am specifically lecturing on juvenile delinquency. It is with this in mind that I would like to touch on Clause 8 by making two short points. Firstly, Senator Hussain mentioned in his contribution the fact that theory suggests that juveniles who commit delinquent or deviant acts can be categorized in two ways, either as adolescent limited or life course persistence. It is in this same vein that I mentioned that the adolescent period is not only a significant and life-changing period of every person's life, but it can also be confusing and scary even if that young person does not have the tools, the environment, or the persons, all known as protective factors, to guide them through this period safely. During this adolescent phase, especially in the middle to late adolescence, persons are not young enough to be deemed incapable of being held responsible for his or her actions, but yet they are still not old enough to make decisions on their own. Adolescence is therefore a period of rehabilitation. It can be a period of rebellion, exploration, and risk-taking, all of which, if you understand adolescent psychology, is normal. More often than not, our adolescents age out of committing any crimes or any deviant acts or delinquent acts during that period known as aging out. This is when they cross from 18 into 19, 20, those ages, as they approach adulthood by achieving behavioral, emotional, and psychological autonomy. This means that they are capable of providing for themselves through holding down a steady job or taking responsibility for their actions and also entering into meaningful relationships. At this phase of adolescent life, especially, as I mentioned, middle to late adolescence, it is important for us that are in charge of the rehabilitation of these young persons that we, one, provide qualified and specifically trained persons who understand the psychology of adolescents and who can contribute to their rehabilitation in a significant way. And two, that we protect their privacy through discreet rehabilitation, allowing for these young persons who committed acts that are against our laws or the laws of our land, so that upon release, they can be successfully reintegrated into a community. This transitional period is a process that should also involve the family and community of the individual. Now, the legislation does not speak to this, but it is prudent that it be noted that several times young persons who offend are placed in these rehabilitation centers and then released back into the community are not afforded any process or guide or program that allows them to be welcomed back into their communities. A case that I was involved in would be a young boy, let's call him Joe, and he murdered his neighbor. Okay, young boys, they got into a fight. It didn't end so well. He was 16 at the time. He was placed in YTC, and upon his release, due to good behavior, reformation, he went through the process of counseling and therapy, etc. Upon his release, he was released back into the care of his mother, into the home where he was neighbors to the person that, the persons that were the parents of the person that was murdered. What happened in that situation was that Joe felt that he could not did not feel welcome back into that community, and his parents could not provide the environment and assistance he would need both psychologically and emotionally to deal with dealing with all those things. In the long run, in the end, he was moved from that area, and needless to say, he got back into a life of crime, unfortunately. All right, so it is in this vein that I suggest that we not only ensure that our adolescents are met with the rehabilitation and specifically trained persons that they need, but that also the family and community is engaged in a process of rehabilitation, all right, where they are sensitized to understand the process of going through adolescence, where persons take risks and are engaged, and sometimes engage in behaviors that may be deemed delinquent or deviant, and that they can change and make a change, and it should not be held over their heads for the rest of their life. All right, the stigma of committing a crime in your adolescence can really ruin your future. My second and final point is that in these new and improved rehabilitation centers, it would be so economic and resourceful to use our graduates, especially from our undergraduate programs in criminology and psychology, who, for these students after 3 to 5 years, would have gained a wealth of knowledge, and then they spend 3, sometimes more months in training. If we can, just during their practicum, if we can somehow integrate the academic program in the universities with the needs of our country and the policies of our government, then we can find a solution that ends up being standardized. So the rehabilitation process from end to end is one that we can track, that we can monitor, that we can evaluate, and so that the end result then would be one that is more positive. I deal with students daily, and when they graduate university, they are so excited to get into the field and show and contribute to their country. But when they cannot find employment, it can be a very disheartening process. So I suggest, maybe when these laws are made, that the academics, the universities are informed as to where the needs are, so that we can then inform the students and change our programs to specifically guide and train our graduates, so that upon their graduation, they can find work and make a contribution that is significant. I thank you.
Honourable Senators, permit me to congratulate Senator Phillips on her maiden contribution. Attorney General.
Thank you very much, Madam President. Madam President, may I thank all honourable senators for very, very useful and constructive contributions. And I genuinely mean that of all persons into this chamber as they came. Our debate has taken us into many places. We have entered into the realm of the esoteric, the philosophical, and then the granular. And I dare say that all of those perspectives have been welcomed and I think are important, because law is never constructed or intended to exist in a vacuum. In fact, our Interpretation Act says that it must always continue to speak. Having vibrant law is quite critical for the benefit of the people of Trinidad and Tobago. After all, we make laws for good governance. Senator Hussain made a rather interesting submission. He said that the piecemeal approach to the development of law is never to be preferred. And he said instead that we ought to go to the root cause analysis and address those things. But dare I say that I hold an entirely different point of view. And I want to say that the view that is held is based upon success. We have spent many a year developing laws in this country. And we've taken the approach where we have to have perfect law. We go for that perfect bill, that structured analysis which takes us sometimes up to 20, 25 years. Senator Mahabir, who has said that he has given us his swan song in the Senate, having spent 8 years in this Parliament, was witness to an attempt to create the Motor Vehicle Authority. And instead, we took a slivered approach of constructing amendments to the laws in relation to motor vehicle and road traffic matters. But in relation to this bill, we are amending 12 acts, 1 general reference to law, that is all written laws. And so we cover 13 general areas of law. But this is the second round of development of the law that we're achieving. The first round came in Act number 6 of 2016, which was the Family and Children Division Act. And in that act, we amended 19 laws. So we did 19 passes. We've done 13 passes on this bill here now. But that came as well with the entire suite of development that we did in the criminal justice system. And that came as well with the entire suite of development that we did in the Ministry of Works and Transport. And that came with the entire suite of development that we did in the children's package. Because we brought to life the Child Rehabilitation Center regulations, the Children's Home regulations, and the order issued under the hand of the Minister of National Security. And that came along with the improvements in the TTPS, where we created a child protection unit comprised of 169 policemen and women. And that came along with UN protocols. And that came along with tracking matters at the charge room, anonymizing them, making sure that we could protect our children from the minute matters are logged into the system. So it's true. This is not simple law. But every member of this Senate who has had the privilege in the last 3 years of participating in debate, I want to ask you all genuinely to download from the judiciary's website the annual report of the judiciary of 2017 to 2018 entitled Improving Court Services. It was issued last night. When we traverse that, and in answer to submissions made by my learned colleagues, it will show reforming processes towards court excellence, case and trial management reform, initiatives to address the criminal backlog, improvements in court reporting, transforming and process reforming and re-engineering through e-strategies. And listen to what has come to life. Criminal Procedure Rules 2016 and its implementation. Criminal backlog analysis and positioning. Improvements in court reporting, digital voice transcription. The Drug Treatment Court. The modernization of the Petty Civil Court and related systems. Small Claims Court. Development and operationalization of new court case management system branded as TTGIM. Transforming traffic courts through a collaborative case flow initiative. Re-engineering probate, the e-registry, court pay, making payments into and out of court easier. Court mail, improving communications. Strengthening internal organizational management. Inside of this, Madam President, we have a complete analysis of the successful implementation of the vast majority of what we have done. And when we go to page 28, Madam President, of this particular report, I want to point out that the traffic division, which is an element of the criminal division, is going to remove approximately 65 to 75,000 matters per year in the magistracy, out of the 143 to 150,000 cases per year. More than half, approximately 62% of the caseload in the magistracy will move into violations. And in doing the strengthened understanding of systemic case flow, the judiciary had this to say, and I want to put it in answer to some of the arguments as to why we should do this. Criminal matters have, and the judiciary has introduced a new column called the probability of disposing of a matter under 1 year. Listen to this one. We've disaggregated civil, non-contentious probate, family, and criminal matters. This is the chance, as we have now captured the data, to have your matter concluded inside of 1 year. Listen to this. Family, non-contentious probate. With the introduction of e-filing, e-searching, we now have a 92% chance that your non-contentious probate will be done inside of 1 year. Civil, we have a 63% chance of your civil matters being concluded inside of 1 year. And listen to this one. Criminal matters, there is an 11% chance of your matter being concluded inside of 1 year. Now, what does that mean? In the civil arena, we have a larger population of judges built on the operation since 2005 of the introduction of the civil proceedings rules, case management structures, computerized environment, use of a judicial support officer, use of judicial research assistants. In the criminal arena, we did not have any of that. It was with the introduction of the criminal proceedings rules, the introduction of a greater complement of staff inside of the respective divisions that we began to de-bottleneck these courts. But Madam President, the reason for Clause 3 of this bill, the reason for the request of greater number of judges, which has occupied the greatest majority of time in this Senate, because that seems to be the one that causes everybody deep concern. The simple reason is that with the creation of the Family and Children Division, and with the move in criminal masters and judges in the criminal division upward, we need more judges. And the data and statistics set out in the annual report of the judiciary demonstrate that if you want to keep everything the same, if you want an 11% chance of having your matter done inside of 1 year, if you want to maintain a 40% disposition rate of new matters filing every year, so every year you take 60% of what you have and you throw it in backlog, every single year. If you want to maintain the law and order and democracy in this country that way, don't appoint any more judges. Accept the advice of the opposition. Rely upon Senator Mark's exhortation to come and talk to us in the opposition. We will consult with you on the amendments to the Constitution, the Honourable Senator says. But dare I say, the evidence demonstrated by the opposition doesn't warn me that that will in fact be successful. We're still waiting on the CCJ to become the final court of appeal. And we have so many others. So the point is, Senator Choate put it this way. The Honourable Senator said something which caused me some concern, but I think she wasn't addressing it to me, that perhaps you said that you were talking to deaf ears. My ears are not deaf, Honourable Senator, and I know that you were perhaps talking to society itself, saying that maybe people are frustrated, and the focus was on the esoteric and philosophical, which I think is very, very important, but I'm now balancing it with the other bit, the practicality. That's why I started with the numbers. That's why I started with disposition rates. That's why I'm telling you about the 11% chance versus the 93% chance in other areas in the judiciary. So let's deal with this allegation, this submission, this necessary focus upon the philosophical side. Should we allow more judges under the current system, and should those judges come from the Commonwealth? That's it, stripped down as bare bones as you can get. Madam President, forgive me, I sometimes forget which house I'm in, having the obligation to sit in both so frequently. Let's start with the supreme law of the Republic of Trinidad and Tobago, the Constitution. Section 2 of the Constitution says the supreme law is the Constitution. Number one, what does the Constitution say? The Constitution says, in relation to the judiciary, that we should have a judiciary. It also prescribes the need for a Judicial and Legal Services Commission. The Chapter 7 of the Constitution, the Judicature, Part 1, the Supreme Court, Sections 99, 100, Court of Appeal in Section 101, 102, 103, 104, appointment of judges. We go into the appointment of judges, and 105 very specifically says this: a person shall not be appointed as a judge or to act as a judge unless he has such qualifications for appointment as may be prescribed. What does that mean? Another law, regulations are going to tell you how you are going to appoint judges. Let's go to the other articulating law. The other articulating law is the Supreme Court of Judicature Act. This is an Act of Parliament, number 12 of 1962. In other words, then, of our institution as an independent republic, as an independent country. Let's look to this. The relevant sections which you're asking to be amended are sections 5 and 6, where we move up from 49 judges to 64. 6, that's in the High Court. Section 6 says we move from 12 to 15 in the Court of Appeal. But listen to this. Section 7. A person shall not be appointed to be a judge of the High Court unless he is, firstly, a member of the Bar of England. That's one category. Or is an attorney at law within the meaning of the Legal Profession Act and is not less than 10 years standing. So there are two categories in the existing law. Either you are a member of the Bar of England, and I'll explain that in a second, or you're an attorney at law in Trinidad and Tobago within the meaning of our Legal Profession Act. The existing law says that you can be a member of the Bar of England. Now, what does that mean? Senator Prescott accepted what I said and retreated from his argument and apologized for misunderstanding it on the last day. But I pointed out to Senator Prescott a very important thing, because Senator Prescott went to Section 14 of the Constitution and pretty much said, let's not appoint people from the Commonwealth. And when the Honorable Senator referenced the Constitution, and when he went to Section 14 of the Constitution, the Honorable Senator was saying this. Forgive me, it's not Section 14, it's Section 18. He read subsection 3. He said countries, in reference to the Commonwealth, are Australia, Bahamas, Bangladesh, Barbados, Botswana, Canada, Cyprus, Fiji, Gambia, Ghana, Grenada, Guyana, India, Jamaica, Kenya, Lesotho, Malawi, Malaysia, Malta, Mauritius, Nauru, New Zealand, Nigeria, Sierra Leone, Singapore, Sri Lanka, Swaziland, Tanzania, Togo, Uganda, UK, and colonies, Western Samoa and Zambia. And he went through a list of why all of those countries could not apply. He said Barbados, not Barbados. He said Zambia, and then he focused upon these things. And then when I pointed out to Senator Prescott that the Bar of England meant that anybody from any country, anywhere in the world, who had spent their entire life in Zambia, their entire life in Lesotho, who managed to get a qualification at the Bar of England, were qualified, he said, oh, I understand the difference. Because we're not talking about people that come from other countries. It's the Bar of England. And anybody could go to law school in England if they enter and do the bar examinations if they pass and be qualified at the Bar of England.
May I ask a question?
Yes, please.
I appreciate that what you're doing is looking at the section. But isn't it also the case that you can practice at the bar only if you go through the Council of Legal Education's law schools, or you are given a certificate by the Attorney General in the jurisdiction to practice? So you might be qualified, but whether you can practice is another issue.
Sure. No, the answer is no. Because we're not talking about practice at the bar. We're talking about qualification to be a judge. There is no requirement in the existing law that you need to be able to practice law in Trinidad and Tobago. And in fact, judges do not have to gain admission to the bar because they're not practicing at the bar. They're practicing in front of the bar on the bench. So there's a material distinction. Yes, we are not talking about a practice at the bar. A judge can come into our jurisdiction by qualification in two things. One, you are qualified at the Bar of England, meaning you can be anywhere in the world and qualified at the Bar of England. And two, you come as an attorney at law under our Legal Profession Act with minimum 10 years experience. That's what this says. So the slingshotting was always the position. The junior lawyers who would be guilty of a miscarriage of justice, a gross inequity, as Senator Choate put it, always had the same position because you can incorporate anybody to come. Now, Senator Choate referenced the speeches on our 50th anniversary of independence. And in that speech, the point out was that in 1962, all of our people at the bench were locals, but they were all called to the Bar of England, more importantly. And the fact is that this position of the bar is important. Now let's go to the other prescription, The other prescription, which I mentioned a second ago, is Section 105 of the Constitution. 105 of the Constitution says you cannot be a judge unless you meet the criterion prescribed. Do we have criterion prescribed in Trinidad and Tobago? Yes, we do. That criterion was prescribed and gazetted in volume 39 at number 68, and this is in the year 2000. And specifically on April 13th in the year 2000, appointments to the office of Judge of the Supreme Court was gazetted. And here's what it says. The Judicial and Legal Services Commission wishes to advise that the matters hereunder constitute its general policies and procedures relating to the above. Puisne judges, qualification for appointment. Puisne judges are appointed by the President, acting in accordance with the advice of the JLSC. They are selected from suitably qualified persons who have been admitted to practice as attorneys at law in Trinidad and Tobago or called to the Bar of England, note the distinction there, as I just said, and are not of less than 10 years standing. Nature of post, appointment. And here's what you must have. Professional competence, legal knowledge and training, intellectual and analytical ability, mature and objective judgment, communication skills, organizational skills, interest in developing the law. Under the column now, integrity, honesty, fairness, ethical standards, independence, commitment to public service. There's another column, temperament, courtesy, humility, emotional balance, decisiveness, authority, social awareness, receptivity to ideas, ability to listen, reliability, and experience. Listen to this. Length and nature of law practice, length and nature of exposure to court practice and procedure, understanding of people and society, public and community service, previous service and judicial and quasi-judicial capacity, specialization, publications, if any. 105 of the Constitution, by prescriptions, gazetted 18 years ago, telling us what the prescriptive elements are, have now satisfied the fact that we can treat with anybody admitted to the bar who is not admitted to the bar of Trinidad and Tobago, anybody admitted to the bar of England. Let's go further. The argument put out to us, and it's an important one, and I accept the philosophical underpinnings that must be examined, as Senator Choate has invited us to look at them, and every other senator has. Madam President, what time do I end precisely? You end at 19 minutes to 8. Thank you. So let's deal with the Commonwealth character. I wholeheartedly agree with the submissions made by Senator Creese, and I do so on the basis of the existing law, the existing practice. The Judicial and Legal Services Commission have been with us since the Independence Constitution. That's point one. In the submissions made, we had the submission about the Commonwealth. And the fact that we should not be looking at people from the Commonwealth, Senator Roach reflected upon Commonwealth practice elsewhere, Senator Simonet reflected upon Commonwealth practice. There was the question asked about reciprocity. Senator Mahabir, you raised the question of reciprocity. So let's deal with the Commonwealth. So number one, let's go back to the Constitution in this concept of Commonwealth. What does the Constitution of the Republic of Trinidad and Tobago, the Supreme Law, say? Section 109 of the Constitution says that the right of appeal to the final court of appeal in Trinidad and Tobago is the Privy Council. The Privy Council is the final court of appeal in Trinidad and Tobago. Who sits on the Privy Council? The entire Commonwealth sits in terms of eligibility on the Privy Council. So our highest court of appeal is populated with persons who can come from the Commonwealth. So let's start with our constitutional final court of appeal. But let's go further. Let's go to the CCJ, because Senator Prescott raised it. Senator Prescott raised the eligibility requirements. I've just reflected upon the fact that we have eligibility requirements, so gazetted 18 years ago, as I've just read out into the record. But let's go further. Who sits in the CCJ? President of the CCJ is from St. Vincent. We have a Trinidadian, someone from England, someone from Jamaica, someone from Belize, and someone from the Netherlands. And specifically, let's go to some of the jurisdictions that I pulled up. because we received a letter under the hand of the President of the Law Association. My dear friend, I say openly, but now I'm going to address what he has recommended to us. The Honorable President of the Law Association said that we should treat with the capacity of the Judicial and Legal Services Commission, we should amend those things, etc., and ask that we do not broaden, in strictest and most wide sense, the move to Commonwealth lawyers. The Honorable President of the Law Association, as a matter of fact, sits as a judge of the Court of Appeal of Belize, he himself. In Belize, the qualification is Justice of a Supreme Court, a minimum of 5 years standing as an attorney at law. Qualification for appointment as a Justice of the Court of Appeal is 15 years standing attorney at law, holding office as a judge of a court of unlimited jurisdiction in civil and criminal law matters. In Belize, one person in the Court of Appeal out of 4 comes from Belize. The other 3 are Commonwealth lawyers. So that's Belize. Eastern Caribbean Supreme Court, comprising the following courts: 6 independent courts: Antigua and Barbuda, Commonwealth of Dominica, Grenada, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, and the 3 British overseas territories, that's Anguilla, British Virgin Islands, and Montserrat. Who sits there? To be a judge or master of the Eastern Supreme Court, a person must have served as a judge in a Commonwealth jurisdiction or be qualified to act as a lawyer in a Commonwealth jurisdiction. So that's right here in the Commonwealth. We're talking about reciprocity. We're talking about Commonwealth Caribbean. Let's go further. Bahamas. Chapter 53 of the Supreme Court of the Bahamas. A person shall be qualified to be a judge of the court if such person is counsel or an attorney who is a member of the Bar of the Bahamas and has practiced for 10 years, etc. Hear this one. Counsel who is a member of the Bar of a Commonwealth country. That's the Bahamas. Let's look at the Legal Profession Act of Trinidad and Tobago. Because we're saying, if we want to err, that the person must be admitted to the Bar of Trinidad and Tobago, which is not the case. Judges who are elected from outside of Trinidad and Tobago need only have the qualification of being called to the Bar of England and Wales. That's it. Section 15 of the Legal Profession Act says this. Subject to this act, a person who makes an application to the High Court and satisfies the court that he is a Commonwealth citizen or CARICOM national and has good character, prescribed qualifications, etc., he may be admitted. So Commonwealthers can come through the Legal Profession Act. Let's deal with the Caribbean Court of Justice. The Caribbean Court of Justice, I gave you the nationalities of people sitting there. Listen to this. Section 10 of the agreement establishing the Caribbean Court of Justice. A person shall not be qualified to be appointed to hold or act in the office of judge of the court unless that person satisfies the criterion mentioned in paragraph 11 and A. Listen to this one. Basically, a person from a contracting party or in some part of the Commonwealth. B. Is or has been engaged in practice, etc., as a member state, etc., or is a member in some part of the Commonwealth. So, honorable senators, where are we going with this argument? Our Constitution permits people to slingshot, dance, enter, maneuver, regardless of citizenship, coming in via call to the bar in England, sit on our courts, have the capacity to do so since 1962, certainly. CCJ as a model, I've just identified the criterion in keeping with Section 105 of the Constitution. Our Legal Profession Act, Commonwealth person to be found. All of the 9 territories I just mentioned in the Eastern Caribbean, all have Commonwealth. The Bahamas has the Commonwealth. The treaty that established the Caribbean Court of Justice has the Commonwealth and even goes further. It has civil law jurisdictions. So, Madam President, let me just say this. Esoteric, philosophical, understood. Facts, Commonwealth is permitted. Reciprocity in other jurisdictions, yes. Now, is it true that we need more judges? hasn't that been the case in terms of argument for umpteen years? Look, the government has addressed systemic issues, debottlenecking, divisions of court, creation of new court, rules of court, all of these things. The creation of a public defender system, which will be up very shortly, the addition of rules of court. But where are we going with an 11% disposition in 1 year in the criminal jurisdiction if we don't have more judges? And you know what? To someone who is a rape victim or a family member traipsing up and down for 11 and 12 years in court to face an accuser because you don't have a judge ready, because your indictments can't be dealt with. Madam President, I'd like to read something. I received a letter as Attorney General. I get them all the time. It's a green piece of paper. It's written from the prisons. And this person from the prisons is writing to me as Attorney General and saying, my name is X. I was born at so-and-so. I was charged for committing a sexual offense upon my stepdaughter, taken to the Arima court. I am desirous of pleading guilty for this offense for which I am charged. I have no intention of wasting the court's time, and I'm very anxious to get the matter dealt with as soon as possible. Here's a man in his own handwriting, writing to me as Attorney General, telling me, I accept the charge of guilt for raping my stepdaughter. I want to plead guilty, and he can't get before a judge because the judicial docket is so blocked that we cannot get somebody into the court for this to happen. Do you have something to say, Senator Amin?
Madam President, I just want to ask the Attorney General, I thought he was going into addressing the shortage issue, the courtrooms, the fact that courtrooms
sure.
are closed.
Thank you. That's a very important point. Thank you, Senator Amin. Yes, under our laws, any court can be appointed anywhere, anytime. Is there a precedent for that? Yes. Who recalls Dole Chedi? Where was that court? We didn't build a new court. We went to Shagaramas, we took the hangar, and we had a court. This summer, the court vacation, the long vacation, 156 inmates went before a specialist court, which was comprised by the Chief Justice, and had their maximum sentence indications done. Why? Because we did the analysis in the prison system. We got the routing up of the court. We managed to clean up the lists. We went into the judiciary backlog statistics. We said, your statistics have got to be wrong. Maybe you've misfiled. Maybe you've done things. But Madam President, the law is beginning to churn right now in a way that has never happened before. And I would like to say, as this letter from this prisoner, and there are many of them, you know, people that have said, I committed murder, I want to be sentenced. People who say, I've raped my child, I want to be sentenced. These are real examples, Madam President, of why our system requires more judges. Now, is it true that the Judicial and Legal Services Commission could do with amendment? Yes. Do we have the time right now to do that? That will require more than a 3/5 majority, possibly, depending upon how we look at it. It's constitutionally entrenched. Do we have the luxury to wait on this system? Dare I say the government's position on this is that we need to press on. And we are pressing on not in a cavalier fashion, but on the basis that we are relying upon the existing law that has prevailed since 1962. Now, Senator Mark read a newspaper article concerning Justice Frank C. Prasad, who, again, I went to law school with, I have a lot of like for. I know Justice C. Prasad well. But let me just make a very simple point.
Attorney General, let me, please. Senator Mark made a reference to an article involving...
You wish me to move on, I will.
I do,
Thank
because
you.
I don't want
Thank
us
you,
to talk about
yes,
judges.
Thank you. I thought you had allowed him, but if you asked him to move on and he did, I'll happily leave the point alone. I will put it this way. Criticisms coming from within certain quarters are criticisms coming from people appointed by the same system. In other words, then, the democracy of these people appointed is preserved. The very people that complain and that have gone public in the fashion that they have were appointed by the same system that they are pouring scorn on now, without indictment and without ridicule. In other words, then, our democracy is live and well. And that's the point I'll make, Madam President. Thank you for your guidance and caution. Madam President, that was the core argument of 90% of the several days that we've spent on this bill. Everybody spoke on that. It falls down to philosophical and esoteric, which is genuinely important, and I thank Senator Choate for reminding us of that, together with the practical. The number one issue in our country, as Senator Ramdeen was reflecting upon, is crime. The consequence is not met quickly enough. We know of the backlogs and statistics. I have come to the Senate on umpteen occasions over 3 years to read them out chapter and verse. We have been participants in the advocacy and in the theory that let's just start. And we've done that. And when you read, honorable senators, the judiciary's annual report, you'll pat yourselves on the back and say, I am grateful that I, senator, as I stood, was part of history in making the system wake up, because it has. Let's deal with a few of the other points. I do propose to circulate amendments to honorable senators. They would have been circulated already. I've circulated a list which has a rationale for the amendment as well. I've also circulated a marked up version of the bill. And coming out of Senator Ramdeen pointing out to me, and Senator Ramkisoon as well, that some of the laws are not fully up to date on the online version, I will circulate some of the consolidated remodel versions of the laws that we are now choosing to remodel. In particular, that which was called the Young Offenders Detention Center, YODA, and now come into Child Rehabilitation Center. So that will allow senators to see the amendments in context. In the 12 specific acts that we're amending, the Interpretation Act is easy. We've dealt with judicial appointment. With the Summary Courts Act, Senator Ramkisoon asked a very important question about the difference between child and young person and older person, effectively, as we've sought to amend the definition. I want to say, Senator Ramkisoon, we're preserving the existing law. All that we did is to harmonize child to mean a person under 18. It falls into consideration under Section 99 and Section 63A of the Summary Courts Act when they are called upon to receive an indication of where they stand, how they may plead, or how it may be dealt, or who supervises or who doesn't deal with it. But we're preserving the existing law. The one that was important really came up in the context of, and I'm just looking for that particular amendment. Madam President, we came to the amendments in the Child Rehabilitation Center Act as an important one because the question about the capacity of the Commissioner of Prisons operating arose in several contributions. And permit me to just explain that. The Child Rehabilitation Center Act is Chapter 1305. We renamed that in 2016 when we moved away from youth offender to child rehabilitation instead. And honorable senators were asking the question or raising the caution. Senator Richards raised it. A couple senators raised it well about the Commissioner of Prisons involvement. And let me explain why the Commissioner of Prisons is there. This Child Rehabilitation Center Act is to provide for the detention of child offenders and children charged with criminal offenses. This is, as if you want to put it in simple terms, it's child jail. Any incarceration facility that we're treating with must be under the hand of the Commissioner of Prisons because it is a detention center within the prisons concept. What we are doing here, very importantly, in Section 2A, is we are adding in that a rehabilitation center shall be under the management and control of the Commissioner of Prisons, subject to, listen to that, subject to the Children's Authority Act and the Children Community Residences, Foster Care and Nurseries Act. In other words, for the first time, we are making sure that the Commissioner of Prisons must act with the Children's Authority and must act with the rules and regulations that have been pronounced. And on behalf of defenseless people in this country, I want to address the Children's Authority for a second. I have had the privilege of working with the Children's Authority, its chairman, its board members, for the entire time that I have been in the position that I currently hold, both with Stephanie Daly, senior counsel, as she was the last chair, and with Hanif Benjamin. And I want to tell you, Madam President, this country owes a debt of gratitude to people like Mr. Hanif Benjamin, who step out of their way, who work day and night on all of the positions that they do. And I take umbrage to Senator Mark having made reflections as he did, because I certainly don't share them, and I think that they are definitely not grounded at all. And I'll just stop there. Madam President, that's the position of the child offender and the Commissioner of Prisons. Some of our honourable senators also raised issues which fall for consideration under the remaining pieces of law as they arise in particular clauses 10, clause 11, clause 12, 13. And when we treat with those particular clauses, I just remind that what we are doing is to harmonize the law in keeping with the amendments that we've made up to recently with the children regulations, both for children community centers, child rehabilitation centers, and children's homes, and also the regulations under the Children Rehabilitation Centers Act. I have 5 minutes. Thank you.
Attorney General, you have 5 more minutes.
Madam President, let's deal with the need for proposed amendments. I do propose that the long title be amended, largely because we, in fact, do not amend the Indictable Offences Preliminary Inquiry Act. That was an inadvertent inclusion. We're really amending the Family Law Act instead, so I regret that insertion. We propose that the Child Rehabilitation Centre Act be amended specifically to harmonize it with the Child Rehabilitation Children's Community Residences Rehabilitation Centre Regulations 2018. And we're proposing specifically that we deal with the prohibited punishment and restraint issues, which are set out in the circulated amendments that I have asked to now sit on your respective desks. We propose that Clause 8L be amended in Clause 12D, again with marginal note. This is to harmonize the fact that we had omitted to put the person with control or responsibility for the child. Similarly, in Clause 9, we are just tightening up the drafting there. We propose, in keeping with an undertaking that I gave in the court pay bill, that we introduce the definition of a collecting officer. I gave that undertaking on the last bill that we piloted, and we propose that we now define a collection officer in the context of the Family Law and Attachment of Earnings Act. Madam President, we also propose to harmonize in Clause 10A1, Roman 1, the definition of appropriate adult. In the Children Community Residences Foster Care and Nurseries Act, in Clauses 11 onward, we're proposing that we bring these in tandem with legislation that we've done recently. So we had the opportunity to tighten this up, because between laying these in the House as it came up, we then went through the two regulations, as the Senate will remember. We did the publication of the other regulations under the hand of the Minister of National Security, and therefore the law has marched on since then. Similarly, for 11CA, 11E, 11F, 11G, 11H, we're harmonizing again with the amendments that we've made as a Senate coming forward. Very importantly, in the Family Law Act, Clause 12A, we are proposing to put in what we passed in the court pay bill, which was approved by the House of Representatives yesterday, and that is custodial trust, bank account, financial intermediary, magistracy, registrar, and clerk of the court. We are also next proposing that we treat with further amendments in Clause 12B3, where we again dealt with the court pay system. We're very importantly proposing a further tightening up of the Family and Children Division Act in how we deal with the anonymizing of records. We felt that the anonymizing of records to protect the identity of children and individuals in the court process was a critically important issue, and we've taken the opportunity to trawl over that some more and to come up with some tighter and better definitions. That in the round, Madam President, is the crux of this legislation. Dare I say, it is critically important. May I urge honourable senators, as I have in sittings prior, to commit to the reform of the law as best as we can. I reject Senator Hussein's recommendation that we ought not to carve up the law into small pieces and move it forward. Sometimes that's the best way to do it. We have been achieving result. The large bills, the perfect product, they go nowhere quickly, as we saw with preliminary inquiries, as we saw with Motor Vehicle Authority, as we're wrestling through with our reform in the financial system. This is the approach that is making difference. Don't rely upon my word. Read Improving Court Services, publication of the Judiciary, its annual report 2017-2018, and I beg to move.
Honourable Senators, the question is that the miscellaneous provisions, Supreme Court of Judicature and Children Bill 2018 be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Leader of Government. Oh, sorry.
A bill entitled An Act to Amend the Interpretation Act, Chapter 301, the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Bail Act, Chapter 460, the Administration of Justice, the Oxyribonucleic Acid Act, Chapter 534, the Legal Aid and Advice Act, Chapter 707, the Child Rehabilitation Center Act, Chapter 1305, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Children Act, Chapter 4601, the Children's Community Residences, Foster Care and Nurseries Act, Chapter 4604, the Children's Authority Act, Chapter 4610, and the Family and Children Division Act, 2016.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I now beg to move that the Senate do now adjourn to Friday, the 21st of September, 2018 at 1:30 p.m. During that sitting, we will complete the committee stage of this bill and carry it through its final stages.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised on the motion for the adjournment of the Senate. Senator Hussain.
Thank you very much, Madam President. Now, I'm sure the members on the other side would have thought that Senator Mark would have been the one rising. But, Madam President, this motion is being brought on education. And the PNM, Madam President, is a brand of incompetence, mismanagement, and corruption in every sector of governance. They have now taken that brand over to the Ministry of Education. And ever since the appointment of the member for REMA as the Minister of Education, the
PNM is a brand of corruption. That is an offense to everybody here.
PNM isn't a member of this House.
Senator Hussain, it is your matter. I would ask you, though, as you present it, to be aware of the standing orders, okay?
And ever since the appointment of the member for REMA as the Minister of Education, the education sector has been in shambles. It is a habitual failure on the part of the Ministry of Education to have schools closed at the opening of the new school year. It shows that after 3 years in governance, the minister has failed to have all schools opened at the beginning of the school year. It seems that this is not a priority of the government to properly educate our young children. The school is the institution in which our young people have to be educated, which should be provided for, guarded, and protected by the government. But this government has not done so. And Madam President, Dr. Eric Williams is rolling in his graves that this current reincarnation of the PNM has deviated from his doctrine that the future of the nation is in the school bags of the children. What this PNM government has done is continue to close schools. It is a crying shame that over 27 schools were closed when the school year resumed earlier this month, on the 3rd of September 2018. Madam President, I am going to quote from a media release by Tutor, dated 3rd of September 2018. Santa Maria RC Primary, structural integrity of the building compromised by earthquake. Madam President, I'm constantly being disturbed by the Minister of Trade.
I don't know what is wrong with this lady.
Senator Hussain, you continue, please.
Nepal Presbyterian Primary, Guayari RC Primary, Barakpur East Secondary, Barakpur West Secondary, La Romaine Secondary, St. Paul's AC Primary, Marabella Boys AC Primary, Marabella Girls AC Primary, Debe Hindu Primary, Presal Government Primary, Arangwes North Secondary, Dego Martin Girls RC Primary, Point Kumana Government Primary, Dego Martin North Secondary, Our Lady of Laventel RC Primary, St. Philip's Government Primary, Mokorapo East Secondary, Matlat Community College, Mount Dore Government Primary, Curep AC Primary, St. Benedict's College, Diana Memorial Vedic, Forest Reserve AC Primary, San Fernando Girls AC Primary. That is Tutor's list. That has been brought to my attention that also Sawa North Secondary and the Milton Presbyterian Primary School are also closed, Madam President.
What do you want in the MPO?
Madam President, they have failed to educate our children. This PNM government is jeopardizing the future of our nation's children due to incompetence in having these schools fully functional.
What do you want in the MPO?
There are hundreds of students who are home and not able to access an education due to these schools being closed. And this falls directly to the feet of this government. Madam President, the minister has no excuse for the closure of these schools, as his ministry has received the largest chunk of the national budget, $7.29 billion. The minister has the resources, but this government lacks the willpower. What this government needs and this ministry needs, Madam President, is vibrancy, exuberance, and energy. And while I appreciate that some of the schools have been closed as a result of the earthquake, I now wonder if or when an inspection was done on these schools, or if any at all, to determine whether or not they are structurally sound. And Madam President, I even understand that some parents are not sending their children to these schools because no assessment has been done with respect to the structure. And Madam President, I also saw an article in The Guardian, and the minister in the Ministry of Education indicated that the Forest Reserve Anglican School, which has about 100 pupils, they were in the process of housing them elsewhere. Then the Santa Maria RC School will temporarily be moved to the constituency office of the minister in the Ministry of Education. Madam President, this is inadequate and unsuitable for any school to be housed in a parliamentary office. I don't know if the Parliament of the Republic of Trinidad and Tobago is aware of the situation. And according to a Guardian article dated the 15th of September, written by Shaliza Hassan Ali, Minister, 27 schools still closed. That's the name of the article. It stated in that article, and I quote, that Garcia is yet to take a note to Cabinet for repair works to be done on schools. Madam President, this demonstrates an overall lack of caring by the government towards the educational needs of our citizens through its continued failure after 3 years. I plead with the Minister of Education, if there are any schools that are still closed, please reopen these schools so that these children can be properly educated. There are the SCA exams, the SBAs they have to do, and the upcoming CXA exams. And Madam President, if I was a teacher and I had to grade the performance of this minister, I would give him an F and send him home. Thank you, Madam President.
Minister of Education.
Thank you very much, Madam President. I smile as I stand to respond to the goodly senator, because his last words were, if I was a teacher. He could never be a teacher using such bad language.
Talk about the schools now, man.
If I was a teacher. Sad. Madam President, it is really disconcerting to hear Senator Hussain spew inaccuracies, falsehoods, and quote from newspaper articles that did not carry the correct information. Senator Hussain quoted an article from The Guardian on Saturday, which stated 27 schools still closed. Senator Hussain did not take the time to read the entire article. Because if he had read the entire article, he would have seen where I reported that 5 schools have remained closed, not 27. And you can check that. Madam President, Senator Hussain again, in his effort to spread inaccuracies, said that he doesn't know whether an inspection or an assessment was done. Madam President, the whole country knows that the Chief Design Officer, accompanied by other senior officials from the Ministry of Works and the Ministry of Education and the EFCL, visited in excess of 66 schools. This was done, and I can name the Chief Design Officer of the Ministry of Works, Mr. Fevek, and he conducted a survey of 66 schools that were affected by the earthquake. Of those, 13 schools were deemed to have suffered some type of damage, and of which 5 were serious. Madam President, I am happy to note today that the 5 schools that suffered serious damage, the students who occupied those 5 schools previously have all been safely housed in other schools or other locations. And let me name them for the information of Senator Hussain so that he can know what is truth and what is fact. The Forest Reserve, Anglican School, I just want to make sure that my information is correct. The Standard 5 students are accommodated at the Superior Road Presbyterian School, and there is an effort to relocate the others at the community center and at a Petrotrin bungalow. The Santa Maria RC School, arrangements are being made to house the children at the office of the Member of Parliament. Now, Senator Hussain said with scorn that he never heard of a school being housed in an MP office. I think we should congratulate the MP from Moruga for his effort at ensuring our children receive an education. That is the important thing. That is the important thing, Madam President, because in some countries, children do not have the luxury of being educated, not even in a building. In some countries, children have to be educated under trees. And the fact that the
under trees, they are shade.
Senator Beaker, you have a choice. You either listen in silence or you will leave the chamber, okay? And for all other members, let us listen to the Minister in silence, please. Continue, Minister.
Thank you very much, Madam President. The QF Anglican School, standards 4 and 5, are at present at the original school in a safe site. Standards 1 to 3 are at the St. Augustine Government Primary School and the Infant Department. That department is housed at the St. Mary's Anglican Home. Diego Girls RC School, the infants and standards 3 and 4 are housed at a safe portion of the school block. Standards 1 and 2 at the Parish Hall and standard 5 at the St. Joseph Hall. The Gallagher RC School.
Come now.
Please leave the chamber at this stage.
Not to the forum,
Please leave the chamber in silence, Senator Obika. Continue, Minister of Education.
Thank you very much. The Gallagher RC School, infants and standard 1 are now housed at the Open Bible Church Hall. Standards 2, 3, and 4 are housed at the Community Center and standard 5 at the Catholic Church. Madam Chairman, I use the opportunity to explain that the 5 schools that were severely affected, every effort has been made to ensure that those children receive an education. There are other schools that are in various stages of dislocation. And I can safely say that every effort is being made to ensure that those children receive an education. Mention was made of the Barkpore East and West Secondary School. Madam President, I have in my possession here a report from OSH, which states that there are no structural defects of that school, and therefore those teachers can come to school and the students can attend school in relative safety. These 2 schools, this is a document that is dated 18th of September 2018, report on refusal to work and investigation at the Barkpore West Secondary School. I have a copy of this. And therefore those 2 schools will open tomorrow. Another mention was made of the Milton Presbyterian School. Again, the County Medical Officer of Health visited the school and he reported that there are no issues at that school that will affect the opening of the school. There are no sewer issues and there are no health issues. The principal, therefore, will be directed to open the school from tomorrow. Madam President, there are a few schools that are still in some stage of worry or bother. The Diego Martin North Secondary School. When school reopened on the 3rd of September, the school was ready to accept its students. However, on examination further, it was found that there were 2 walls that were insecure. As a result of this, the school was closed, but those 2 walls, we have appointed a contractor and work is going on, and those schools have been assured, those walls will be reconstructed and have been assured that that school will be opened on Tuesday. The Laramin Secondary School is a school that suffered an electrical fire. The contractor was working assiduously, and he has informed us again that that school will be ready for opening on Tuesday next week. The Sour North Secondary School suffered electrical problems.
Minister, you have 1 more minute.
Thank you very much. And that school also will be reopened on Tuesday. Of all these schools, we have 3 schools who will be reopened immediately, and that is tomorrow. And we have 7 schools that will be reopened on Tuesday. In other words, all the schools that were affected by the earthquake and by other circumstances will be in readiness to accept all our students by next week, Tuesday. Thank you very much.
Well done. Yeah, thank you. Thank you very much, Madam President. Madam President, in this anti-worker, anti-people and anti-Trinidad and Tobago government's haste to crush, destroy, and break the powerful oil fields workers' trade union, which recently celebrated 81 years of existence in this country. This government has spared no effort in misleading the country, in peddling misinformation, half-truths, and literal innuendos, and what people would call terminological inexactitudes. Madam President, would you believe that the government has taken a decision to shut down not only the refinery, but the whole of Petrotrin? Some people are predicting that the whole of the Southland, from which you are from, is going to be decimated by this decision. Madam President, some 9,000 to 10,000 workers are going to be affected directly as a result of this callous and brutal and reckless decision taken by this administration. Madam President, it is estimated that close to 100,000 citizens are going to be indirectly affected by this move. But you know what is worse, Madam President? I do not believe the government has thought this thing through properly. Because, Madam President, what is the state of supply of LPG for the consumers of this country? The government has made no statement as to what will happen when the Petrotrin refinery shuts down, because they have been supplying LPG to this country at a subsidized price. We don't know if the price will increase. We don't know where the supply will come from, because the government has not told the country, Madam President, what will happen to LPG supplies in this country. We are in the dark. The people are in the dark. Madam President, there is a byproduct that is derived from crude oil when it is refined at the refinery. It is called bitumen. That is essential. It is an essential ingredient for road paving in our country. Madam President, that is a product that is given free by Petrotrin to Lake Asphalt. What will happen when you sell out our patrimony to Sinopec and Perenco? What will happen? Madam President, what is even more alarming is that the government has not indicated to this country what will happen when this event takes place in terms of the supply of bitumen to our country, to the Ministry of Works and Transport, and to other agencies that engage in road construction. Madam President, we learned today, this evening, that this criminal, I think you would want me to say that, this heartless and reckless and irresponsible government has now deployed, and I call on the minister to deny this evening, that they have deployed the army, and the army has now moved into Petrotrin to secure the assets of Petrotrin. I want the minister to deny that this evening. We have seen evidence of that, where the army is moving into Petrotrin this evening. And this is the callous behavior of this government. This government is courting revolution. They are playing with fire in this country, if you continue along that line. Madam President, what is even more alarming, this minister, the Honorable Minister of Energy and Energy Affairs, he gave an undertaking to our CARICOM colleagues. He said, don't worry, when we shut down the refinery, everything will be okay. Madam President, that is not so. Grenada is in panic. St. Vincent is in panic. Barbados is in panic. Dominica is in panic. You know why? Because the minister simply was not telling the truth when he said that everything is going to be all right with our CARICOM friends. Madam President, I quote from the newspaper, Saturday, September the 15th, 2018, Newsday, page 20. The headline is Barbados finds new supplier. Barbados finds new supplier. And it reads, Madam President, if you'd allow me, Barbados has found a new supplier for petrol now that the Trinidad and Tobago government is planning to shut down its oil refinery. It goes on to say that while the government will try for a cheaper deal, it certainly has no plans to pay more for the refined fuel, and there will be enough stocks from the old supplier to last until a new import deal is in place. Abrahams told Online News. That is the Minister of Energy, Wilfred Abrahams. Madam President, so who are we to believe? On the one hand, the Minister and the Honorable Prime Minister says to this country, only 1,700 workers are to go home. Madam President, we come and get from the chairman of Petrotrin, Espine, Wilfred Espine, 3,500, 3,700. We got from Minister Khan, the Honorable Minister, in the other place yesterday, it is over 4,700. Madam President, we are now hearing from the OWTU, it's the whole company going to be shut down, and you're talking about over 5,000 workers, and another 5,000 belonging to contractors, that is workers, so you're talking about 10,000 workers or thereabouts. And then we are talking about people who are going to be indirectly affected. Madam President, we are hearing from this government that they are going to be importing petroleum products. They don't have foreign exchange to buy the oil, Madam President, for the refinery. But they're shutting down the refinery, and they're going to find money to import oil. Madam President, this is something unbelievable. You want to know if you are spinning out of control. Is this government for real? What is this government doing to our beautiful country? They have wrecked the Tobago economy, and they are now trying to wreck the Trinidad economy. What is the objective of the PNM? So, Madam President, the minister must get up this evening and tell this country, one, what is the state of play with LPG? What is the state of play with bitumen? What is the state of play with petroleum products to our CARICOM market and our partners in CARICOM? He must also clear the air on the invasion of the army at Petrotrin as we speak today. And what is the purpose of invading Petrotrin at this time? You must tell the country these things because, Madam President, it is unacceptable, it is indefensible, it is a legacy, it's a dark day in our history. And this country, I hear the Prime Minister say that history will absolve him. Madam President, will history absolve you for closing down the flagship company of our nation called Petrotrin? I don't believe so, Madam President. I think it's a matter of time before the dustbin of history sweeps this government completely out of history. Because, Madam President, we cannot continue to allow a government to be so insensitive to the needs of the people. Madam President, I am predicting that if the government does not reverse that decision and do it quickly, sit down with the OWTU, sit down with the government, OWTU, and all the major stakeholders, and put your heads together and find a solution, Trinidad and Tobago is going to be going through a period of permanent instability for the next few months until they have elections and until the people have a chance to kick out the PNM and get rid of them once and for all. I thank you very much, Madam President.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, my only regret tonight is that this wasn't a full debate, so I would have had 40 minutes to reply to Senator Mark. I have gone on record, the Prime Minister has gone on record, the Board of Petrotrin has gone on record, outlining the challenges that this company faces, the serious systemic risks it has posed to the economy. Okay? We have explained in no uncertain terms why we had to take the decision we took. As hard as it is a reality that this nation has to accept. I say no more on that. But in taking the decision, granted I'm aware, as I said publicly, I am aware of some of the grave consequences of this action. But as leaders, sometimes you have to take difficult decisions. The first thing the UNC is trying to do is spread panic to the country. Gas prices going up. There'll be a shortage of gasoline. They say we got back to the days of Muscovado sugar because you stop a refinery and you're exporting crude, even though there's greater value in that thing based on the configuration of the refinery. But let me deal specifically with the 3 points that Senator Mark was making: LPG, bitumen, and fuels to the CARICOM market. Madam President, the demand for LPG, which is liquefied petroleum gas, which is propane basically and butane that we cook with, is 2,400 barrels per day. And it peaks around Christmas time to 2,800 barrels a day. 100% of that market was supplied by the Petrotrin refinery. But what is not known to this population, and I'll bring it to their attention today, that there are 2 other producers of LPG in Trinidad. PPGPL, which is Phoenix Park Gas Processing Limited, which produces 6,500 barrels of LPG per day. And Atlantic LNG, which PPGL markets their product, 6,200 barrels per day. So the total local production, apart from Petrotrin, is 12,700 barrels per day. The local demand is 2,400 barrels a day. Could be easily supplied by PPGPL, and the rest is exported largely to CARICOM and the Americas. All we have to do now, we are working out the logistic of a seamless transition from Petrotrin providing the LPG to PPGPL providing the LPG. Because the LPG is a function of the refinery process. From crude, you take the light end of the gases. But in gas, there's also the heavy end of gas, which is called wet gas, where you strip the liquids from it. And that is the role of the most profitable downstream company to the state in Point Lisa's, PPGPL. So they have a tremendous supply of LPG, and they will supply the market. Seamless transition. There's absolutely nothing to worry about. On the bitumen side, the average consumption of bitumen in Trinidad is 9,000 barrels per month. That bitumen was supplied as a, what you call, a bottom-end barrel product, not a high-value product. You cannot run a refinery to make bitumen. It will be the maddest investment and economic decision on the planet. So you cannot run a refinery just to supply a bitumen market. Bitumen is virtually a byproduct. He's right. So the fact of getting a supply of bitumen for the local market has nothing to do with the shutting down of the refinery. Over the years, Lake Asphalt Trinidad Limited has been marketing the bitumen on behalf of Petrotrin. The Prime Minister has gone on record to say Lake Asphalt is a PO box for Petrotrin. What will happen now is that the 9,000 barrels a day will be imported by Lake Asphalt for distribution into the local market. We are now working out on a seamless transition from getting this product and sending it out to the market. The difference is the marketing arrangements, the supply chain that reaches the customer. It's seamless. There'll be no difference. The only difference is that the source of supply will no longer be the refinery. The source of supply will be the very tanks that the refinery was using. It's just the source of supply will now be imported products for that stream. The consumer doesn't see the source of supply, you know. The consumer sees the supply. There's no color code for foreign gasoline or a color code for foreign LPG. It will be as seamless. So in terms of the consumer, there will be absolutely no difference. Let me deal with this third point, the CARICOM market. The same philosophy applies. We will be honoring our supply contracts to CARICOM. We will be importing crude. We will now become a trader and a terminaling facility for crude supplies for onward shipment to CARICOM market. One of the advantages that Trinidad had all along was that the CARICOM market is no big market. You know. No tanker is going to pull up in Dominica to drop 3,000 barrels of fuel. It is totally uneconomic. The world today is about trading and large tankers on the major shipping routes of the world. So that niche market was handled by Petrotrin in small packages. The only difference would be the packages will be packaged, just to be redundant, from products that you import and terminal at point of pay for onward shipment into CARICOM. So again, it is seamless. Whether it is in Barbados, whether it is in Grenada, in St. Vincent, St. Lucia, Dominica, they do not say it's a red color for Trinidad refinery gasoline and a blue color for imported gasoline. No. And what we have to understand now is that Petrotrin will be involved in trading. Because trading is where the money is. There's money in refining, you know. If you have an efficient, well-run, and optimized refinery. We do not have that. And there was no chance, like a snowball in hell, for that to ever happen. That is why we had to take decision what we have. There's one issue with the importation of crude, of finished products for re-export into the CARICOM market is the issue of the CET. Because it will now be determined to be foreign product subject to CET. However, I think there will be a case to be made to COTED to lift and suspend the CET on petroleum products. And once that is done, at a reasonable time, at the headquarters in Georgetown, I think all will be well. And the whole issue of Petrotrin shutting down has nothing to do with the supply of the fuels market to CARICOM, the bitumen market locally, nor the LPG market. It is far more fundamental than that, Madam President. But I just want to put the nation in a comfort zone that there will be absolutely no shortage, no lack of supply, no break in supply for LPG, bitumen, and the CARICOM market. With those words, Madam President, I thank you.
Honourable Senators, the question is that this Senate do now adjourn to Friday, the 21st of September, 2018 at 1:30 p.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Friday, the 21st of September, 2018 at 1:30 p.m.